Carelessly causing harm, part 2. In the previous video we saw that in order to establish that a defendant has committed the tort of negligence, we first of all had to show that the defendant owed the plaintiff a duty of care. However, the existence of a duty of care is not enough to establish negligence. There are other requirements. The second requirement is that the defendant has in fact breached their duty of care, that they have been careless in some way. The test used by the courts to establish carelessness is the reasonable person test. To establish a breach of duty, it must be shown that the defendant failed to do what a reasonable person would have done in the same circumstances. If the defendant failed to do what the court believes a reasonable person would have done in their shoes, the defendant has been careless. They have breached their duty. The court will take into account a number of factors in deciding whether or not the defendant has breached their duty. One factor is the probability of harm. The more likely it is that somebody could be hurt, the more careful the court expects the defendant to be. The less likely it is that someone will be hurt, the less careful the court expects the defendant to be. In Bolton and Stone, the facts were that the plaintiff lived in a house adjacent to a cricket ground and was injured when a cricket ball flew over the fence and hit her in the head. The legal issue was whether the cricket ground had breached its duty of care by failing to do what a reasonable person would have done in the same circumstances. The court decided that the likelihood of a cricket ball going over the fence and hitting someone in the head was so low that a reasonable person would have done exactly what the club had in fact done when it built its fence around the club. The cricket club had not breached its duty of care and was not liable for the harm caused by the cricket ball. The court will also take into account the likely seriousness of the harm. The more serious the potential harm or injury to the plaintiff, the more careful the court expects the defendant to have been. The less serious the potential harm to the plaintiff, the less careful the court expects the defendant to have been. In Paris and Stepney Borough Council, the facts were that Mr. Paris was an employee of Stepney Borough Council. Mr. Paris was engaged to work on vehicles with tools that exposed him to the risk of a spark from the use of the tools going into his one good eye. Mr. Paris only had one good eye, having lost the other eye during the war. The council did in fact offer employees the opportunity to wear safety masks, but did not enforce this requirement. And when Mr. Paris was injured, when one of those sparks did in fact fly into his one good eye, rendering him completely blind, he commenced legal proceedings against the council for compensation. There was no question whether or not the council owed Mr. Paris a duty of care. It certainly did. The council was Mr. Paris's employer. The question was whether the council had breached its duty of care. Had the council done what a reasonable person would have done in the same situation? Should the council have insisted that Mr. Paris wear a safety mask? The court decided that given the likely seriousness of the potential harm to Mr. Paris, given the fact that he only had one good eye, and that an injury to that eye would have been extremely serious for Mr. Paris, that the court's expectation was that the employer should have compelled Mr. Paris to wear a safety mask. The fact that the employer had not done this meant that the employer had failed to do what a reasonable person would have done in the circumstances, and had therefore breached its duty of care. The court will also take into account the burden of taking precautions. If the only way the defendant could have avoided the risk of the particular harm was by taking extremely expensive or onerous precautions, then the court is less likely to decide that the defendant has breached its duty of care. But if the defendant could easily have avoided the injury or harm to the plaintiff by taking a few simple, relatively inexpensive precautions, and they failed to do that, then that would more than likely lead the court to conclude that the breach of the duty has been breached and the defendant has in fact been careless. The third requirement is that the harm suffered by the plaintiff was in fact caused by the defendant's breach of duty. There are two elements to this. The first element is factual causation. The plaintiff must establish that the careless act of the defendant caused, either directly or indirectly, the harm suffered by the plaintiff. In other words, there must be a clear chain of causation from the defendant's careless act to the harm caused to the plaintiff. In Yates and Jones from 1990, the facts were that the plaintiff, who was injured in a car accident caused by the defendant's carelessness, became addicted to heroin while in recovery and having to deal with the pain caused by the accident. The question was whether the cost to the plaintiff of that heroin addiction, i.e. the money that the plaintiff had to spend purchasing heroin to satisfy the addiction, was caused by the defendant's carelessness that led to the accident. Was there a clear chain of causation from the defendant's careless driving through the car accident to the injury suffered by the plaintiff to the heroin addiction and the money spent by the plaintiff on heroin? The court decided that the element of causation was not established, that the heroin addiction was not caused by the car accident in the sense that the plaintiff could have become addicted to heroin anyway. The second element of the third requirement is scope of liability. The harm suffered by the plaintiff must be a reasonably foreseeable consequence of the defendant's carelessness. If the harm suffered by the plaintiff was not reasonably foreseeable, then the defendant will not be responsible for that harm. In other words, a defendant is only responsible for the reasonably foreseeable consequences of their carelessness, not for harm that was not reasonably foreseeable. In Roe and McCartney from 1976, the facts were that the plaintiff was the owner of a sports car which she allowed her friend, the defendant, to drive. Both were in the vehicle at the time that the defendant caused the vehicle to crash. The defendant was rendered paraplegic, and the plaintiff, following the car accident, was so consumed by guilt over the fact that she had let her friend drive the car that she suffered psychiatric trauma and had to be treated. She sued her friend, the paraplegic, who caused the accident, in the tort of negligence. Did the friend owe the plaintiff a duty of care? Yes, she certainly did. A driver owes a duty of care to the passenger in the vehicle. Had the defendant breached her duty of care? Yes, her careless driving caused the accident. But was the psychiatric harm suffered by the plaintiff over the guilt a reasonably foreseeable consequence of the defendant's careless driving? The court decided that it was not. Even if all three elements of the tort of negligence are established, a defendant can still avoid liability if they can establish the existence of one of the defences that are available. The first defence is voluntary assumption of risk. If it can be established that the plaintiff was fully aware of the risk at the time the harm was caused, and they voluntarily assume that risk, the defendant is relieved of all liability. For example, if a plaintiff ignores a sign clearly warning them of the risks of climbing into a bull field and they are injured by a bull, were they to sue the farmer in the tort of negligence, the farmer would be able to rely upon the defence of voluntary assumption of risk. The plaintiff knew the risk and voluntarily assumed the risk by climbing the fence. In Insurance Commissioner and Joyce, the court explained that a person who gets into a motor vehicle being driven by someone who they know to be drunk cannot later sue the driver if there is a car accident, because a person who gets into a vehicle being driven by someone who is clearly drunk voluntarily assumes the risk of a car accident. Another more common defence is the defence of contributory negligence. And that's where, even though it's been established that the defendant has been negligent, the defendant is able to show that the plaintiff themselves has been negligent and has failed to look after their own safety in some way. If it can be established that the plaintiff contributed in some way to their loss or injury, then the liability will be apportioned or divided between the defendant and the plaintiff. In Ingram and Britton, the facts were that the plaintiff was injured when the tractor he was driving rolled over, and because the defendant, their employer, had failed to install a safety bar over the seat, the plaintiff was seriously injured. The plaintiff commenced legal proceedings against their employer, the defendant, in the tort of negligence. The court was easily able to conclude that the employer owed the plaintiff a duty of care, and that the employer had been careless in failing to install the safety bar, and that carelessness did lead to the injury suffered by the plaintiff. However, the court also observed that the reason that the tractor rolled in the first place was because of the plaintiff's careless driving, and concluded that both parties had been careless, both parties had been negligent, and apportioned liability between the two, 60%, 40%, so that the plaintiff only received a proportion of the compensation that they were claiming. There are many other defences to the tort of negligence available under tort law. Barristers, for example, are immune for the things that they do while representing their clients in court, so a client in court who is unsuccessful cannot sue their barrister for negligence. People who volunteer to work for charities free of charge are generally protected from civil action in the tort of negligence. Similarly, emergency service providers such as volunteer firefighters and lifesavers are accorded a degree of immunity from the tort of negligence, and professionals who are complying with standard practice within their profession will be deemed to have complied with their duty of care, even if the court is of the view that it was not what a reasonable person would have done in the circumstances.